When it comes to Drake, what we are covering today is not a rumor or an exaggeration. It is completely real, and it is one of the most extraordinary things any public figure has done in recent memory. Because Drake is not just appealing a court decision, he is attempting to dismantle 40 years of established legal precedent, to literally rewrite New York defamation law in order to avoid accepting a rap battle loss. Nothing of this kind has ever been attempted before in any dispute connected to this genre.
Leave a like, subscribe, and stand with this conversation, because what Drake's legal team is currently arguing in court is some of the most transparently desperate legal maneuvering we have ever seen from any public figure. The embarrassment has been so complete and so sustained that the only move left, apparently, is to try and change the rules of the game retroactively, and that is exactly what is happening right now.
UMG's latest response to Drake's appeal has been circulating, and the more people examine it, the more clearly the full picture comes into focus. What has been underreported until now is the specific legal strategy Drake's team is actually pursuing, and when you understand what they are genuinely arguing in court, one thing becomes immediately clear. Drake knows this case is failing, and what we are watching is someone doing the most extreme thing available to them rather than accept the outcome.
Everything Drake is focused on right now has nothing to do with music. It has nothing to do with Iceman or any album or any creative work. His entire attention is directed at finding any legal pathway back from this lawsuit, any mechanism available to reframe the case, extend the fight, or generate enough leverage to settle the score with UMG and the rap world. And the two options his team is currently considering are both so extraordinary that they require careful examination to fully understand.
There are two directions Drake is reportedly weighing, and honestly, ranking them by embarrassment level is difficult because both are remarkable in their own way. What is being seriously discussed and actively argued in this legal proceeding is something that I genuinely believe represents the most legally audacious move any artist has ever made in the history of hip-hop disputes, not just recently, across the entire genre, and it deserves to be examined precisely.
UMG's response filing, specifically around page 40, is where the clearest picture of what Drake is attempting emerges. The filing states that Drake's legal argument fundamentally misreads New York defamation law. Specifically, Drake's team is arguing that the broader context surrounding Not Like Us, the full 16-day beef, the 6 diss tracks that preceded it, the entire documented exchange between Drake and Kendrick should be excluded from how the court evaluates the song. Drake's position is that global listeners of Not Like Us would not necessarily have had full knowledge of the preceding beef, and therefore the song should be assessed as if it existed in a vacuum.
The significance of this argument is hard to overstate. What Drake is attempting is to roll back 4 decades of established New York defamation law, replacing the existing standard, which requires statements to be evaluated within their full context, with a narrower interpretation that even the Court of Appeals has not applied since a 1986 case called Steinhilber. The goal is to strip away all context from Not Like Us so that Kendrick's words can be evaluated as if they were isolated factual claims, rather than the closing salvo in a documented competitive rap exchange.
What this strategy is designed to accomplish is clear. If Drake can convince the court to remove the context of the beef, to evaluate Not Like Us as though no prior diss tracks existed, then he can argue that Kendrick's allegations were presented as factual statements rather than hyperbolic opinion in a competitive creative context. It is a legally creative approach. It is also a completely transparent one. And UMG's response is focused specifically on making sure every decision-maker involved understands exactly what Drake is attempting to do and why it fails. The Steinhilber precedent Drake is trying to dismantle is worth understanding in its own right. In 1986, a union worker named Louise Steinhilber crossed a picket line during a strike and was subsequently targeted with public statements and signs by her union. She sued for defamation. The court ruled against her, establishing that statements made in the context of heated public disputes, statements that cannot be proven literally true or false, are protected as opinion and cannot form the basis of a viable defamation claim. The parallel to Drake's situation maps almost perfectly. In a rap beef, both participants enter the exchange understanding that the other party is going to take genuine tensions, documented rumors, and real grievances and amplify them through hyperbolic bars. That is the foundational creative contract of the genre. No informed listener processes a diss track as a factual legal deposition, and the legal protection that flows from that understanding, from the recognition that rap lyrics exist within a context of creative expression rather than factual reporting, is precisely what the Steinhilber precedent establishes. Drake is arguing that this protection should not apply to him.
And that is the dimension of this that should concern every person in this culture, not just as a Drake story, but as a story about artistic freedom. Because if Drake succeeds in narrowing this legal standard, the precedent applies universally. Every future diss track, every piece of competitive creative expression that names a real person, every artist who says something pointed about someone with resources and a willingness to litigate, all of them would be operating in a legal environment that Drake is actively trying to make more hostile to artistic expression. He is attempting to hand powerful people a weapon that this precedent has kept out of their reach for 40 years.
And the specific position Drake has placed himself in, on the same side of this legal argument as a worker who crossed a picket line and then sued the people who publicly criticized her for it, is not incidental. It is revealing. Because throughout this lawsuit, Drake has framed himself as someone protecting the industry and advocating for future artists. What he is actually doing is attempting to strip away the legal protection that keeps those same artists from being sued by people more powerful than them for saying things those people do not want said. The gap between the stated purpose and the actual effect of his legal strategy is total.
And then there is the second option being seriously discussed. UMG's response filing includes a line, almost as an aside, that has generated significant conversation in both legal and hip-hop circles. The label's filing notes that Drake's arguments about Kendrick's mental state and intent are irrelevant to the case against UMG specifically, and it adds, in passing, that such arguments would only be relevant if Drake had chosen to pursue the actual author and performer of the song he is claiming is defamatory, meaning Kendrick Lamar directly. That one observation from UMG's filing has opened a conversation that most people hoped would not be necessary.
The implication of that line is direct. UMG is essentially telling Drake that he identified the wrong defendant. If the argument is that Not Like Us contains defamatory content, then the case, if it has any legal foundation at all, belongs against the person who created the content, controls the masters, owns the publishing, and made every creative decision behind the record. It belongs against Kendrick. And now, with the UMG case collapsing and options narrowing, the question of whether Drake pursues Kendrick directly has moved from hypothetical to genuinely possible.
The widely held belief in the culture has always been that Drake wanted to go after Kendrick from the beginning, but chose UMG as the target, because the optics of suing a rapper for winning a rap battle were too damaging to absorb publicly. Going through the label allowed him to frame himself as a victim of institutional power, rather than as someone using the legal system against a creative competitor. But that framing has been steadily eroding as the case has progressed. And if the UMG case gets dismissed entirely, the indirect route is gone, and only the direct one remains.
And suing Kendrick directly would be a categorically different kind of exposure than anything the UMG case created. Suing your label allows you to position yourself as an artist standing up to corporate power. Suing another rapper for the content of a diss track removes all of that positioning entirely. You are no longer David against Goliath. You are the person who could not accept losing a creative competition and chose litigation as the response. The sympathetic framing disappears completely. And what replaces it is the most unflattering version of the Drake story, told entirely through public court documents. And what Drake would actually need to establish in that courtroom to win is where the strategy collapses entirely. A defamation claim requires demonstrating that the statements made were false, that what Kendrick described in Not Like Us was an inaccurate representation of Drake's actual character and behavior. And the specific patterns Kendrick referenced in that song are not allegations Kendrick invented. They are documented patterns of behavior with independently verified records attached to them, reported on, photographed, and publicly discussed long before Not Like Us existed.
The documented pattern of Drake engaging with very young women, tracking specific birthday milestones, the Bella Harris situation, the Millie Bobby Brown situation, all of this exists in the public record entirely independently of anything Kendrick said. And beyond that, in the tailor-made freestyle, Drake explicitly invited Kendrick to discuss his preferences in women and his behavior around them, creating a documented, on-record opening for exactly the conversation Not Like Us represents. That invitation, in any competent courtroom, becomes a consent document. It dismantles the defamation argument before the first witness is called.
And the discovery process in a direct lawsuit against Kendrick would be one of the most damaging public events of Drake's career, and that framing already accounts for how damaging the last 2 years have been. Because discovery in that case means Drake's documented history, his own public statements, and his own rap lyrics all become court-accessible evidence. And every journalist, every rapper, and every person covering that trial would have full visibility into all of it. The exposure would go far beyond anything that has already come out.
And the broader cultural damage of attempting this goes beyond Drake personally. If a successful precedent is established, if rap lyrics can be used as the basis of defamation claims by stripping them of their creative context, the effect on free speech in hip-hop is severe. Artists like Young Thug, who already had to fight for the right to have his own lyrics treated as creative expression rather than criminal evidence, would face an even more hostile legal environment. The framework that has always protected rap's capacity for exaggeration, hyperbole, and pointed creative attack would be structurally weakened. And Drake's stated reason for this lawsuit has never been about protecting that framework. It has always been about dismantling it for personal benefit.
And the contrast between what Drake and J. Cole are actually doing right now versus how they are being positioned in broader conversations about hip-hop leadership is worth naming directly. Drake is in court actively trying to eliminate legal protections that every other rapper in the genre depends on. J. Cole is in interviews suggesting that the industry conspired against Drake, while saying nothing about the lawsuit that threatens creative freedom across the genre, including for artists in his own circle. Neither of these positions represents what hip-hop actually needs from the people who have benefited most from it. Because this culture was built specifically on the freedom to say things that powerful people do not want said. It was built on artistic expression that challenges, provokes, and tells uncomfortable truths without requiring the approval of the subjects of that expression. And watching one of its most commercially successful figures spend enormous resources trying to build legal mechanisms that would restrict exactly that kind of expression, while another frames a fabricated conspiracy as the real issue, is a specific and dispiriting failure of responsibility from both of them. And the honest assessment of where Drake's legal strategy ends is this: he does not have the actual willingness to sue Kendrick Lamar directly. He understands what would emerge in discovery. He knows the documented record exists and that bringing it into a courtroom would be terminally damaging. So the more likely outcome is a continuation of what we have already been watching: extended appeals, rewritten legal arguments, ongoing legal fees, rather than the one step that would force everything into the open at once. And that calculation, that specific choice of prolonged legal attrition over direct confrontation, tells you exactly as much about Drake as any diss track ever has.
This is what the Iceman era actually is: an album that does not exist, a lawsuit that is collapsing, a legal strategy designed to erase 4 decades of free speech protection in the genre Drake claims to represent, and a person who built his entire career on a culture he is now actively working to constrain for his own benefit. Keep watching, because if he does ultimately file against Kendrick directly, nobody should be surprised. The trajectory of everything he has done points in exactly that direction. Check out the suggested video to see what Drake did immediately before all of this that made the whole situation significantly worse.